hard to acquire over time are taken care of. So, without any further ado, please help me welcome Bill Bronchick. Bill, thanks for joining us.
Great. Thanks, Mike. I appreciate it. I appreciate everyone for taking the time tonight to spend with us, learn some new ideas that I'm sure are going to be very effective and valuable for you in your business. And we're going to talk about how to protect yourself, your business, and your family from lawsuits, liability, taxes, and other financial pitfalls. And at the end, we'll do some Q&A if you have any questions. I believe there's a couple of places you can pop in questions here. Chat, Q&A, and then there's a raise hand feature, but frankly, I've never used that. It's like a radio station. You raise your hand and then you get unmuted. I think it'd just be more efficient. I'll do a presentation for about 45, 50 minutes, and then we'll just do some Q&A as long as you need. All right? All right, so let's get started. So my bulletproof asset protection system that I have worked on for the better part of 35 years as an attorney, businessman, investor, helping people to protect what it is that they have accumulated. It's not just what you make, it's what you keep. And there are offensive and defensive strategies in business, and particularly in real estate. We're going to be talking about the defense tonight, how to protect yourself from the inevitable, well, let's just call it a fumble. You make a mistake, or even if you don't make a mistake, you don't do anything wrong and you still get sued. That's just an unfortunate reality of our society today, that people like to blame other people for their problems, and hopefully they don't blame you. There are 4 steps to success with this method, and let me go over them in outline form, and then we'll go each topic one by one and give you a little more detail and get you started. Number 1, probably the most effective one, is appearing broke. Now, I don't mean the way you dress, although and what you drive, but if you drive around dressing up in fancy suits and driving fancy cars, people get the impression that you're loaded. In some professions that's necessary, but I'm talking about more on paper. If people are looking for your assets, if they're searching public records, what will they find? Now, the other ancillary to that is, if they find your assets, let's say your real estate, which is very public, very easy to find on the internet, will they find it free and clear, or will they find it with many liens on it? And their attitude might be, or their attorney's attitude might be, well, get in line. It seems like they're leveraged out. I remember in the late 80s, I'm from New York originally, and Donald Trump was being interviewed, and this was when things were really bad, and the real estate crash and his casinos and everything was going terribly for him. And a newspaper reporter said, "Hey, Donald, how's it going?" And he says, "Well, you see that guy pushing a shopping cart over there with the cans in it? He's worth $70 million more than me." And of course, what he meant was he was upside down and over leveraged. And as we know the story, he went back to banks, borrowed more, and turned himself around in that situation. But the point is, if they can't find your assets, or if they do find it, it appears that it's not worth going after, you're just going to eliminate 90 to 95% of the amateur lawsuits and claims. When people think you're not worth going after, or you don't have anything substantial to go after, they're just not likely to do it. Lawyers like to get paid. That's just the fact of the game. And if they don't see an obvious way to get paid, meaning that there's a pot of gold at the end of the rainbow there, if they get a judgment against you, then they're more than likely to tell their client, "I'm sorry, I can't really help you here unless you want to pay me by the hour." And that's rare, and except for someone who has a personal vendetta, or an ex-business partner or ex-spouse or something like that. But the average person just can't afford to pay litigation rates by the hour. So number 2 is we want to create a liability shield. Once they get past the first filter, the appear broke, we want to make sure that there's a shield of liability between you and the assets that you own that can create liabilities. Now, certain assets are safe, So cash and stocks and securities and mutual funds, you're not going to get sued simply by owning those. They don't create a liability as opposed to owning a business that has customers, has its retail, and has employees, or you own real estate and you have tenants and you have guests. Those are the types of things that will create a liability. And we want to put a shield between you and the liabilities that those assets create. Number three, we want to segregate those assets into different baskets. So we want to put the safe assets in one basket and then the risky assets into another or multiple baskets so they don't poison each other or the safe assets. A lot of people will have a business and they just put everything in one pot, and that's risky because even if you're using a liability shield, you can, as we'll discover, lose everything with one lawsuit. And finally, number four, becoming legally judgment proof. That is, if someone does get through 1, 2, and 3, and they do get a judgment against you, or the IRS files a lien against you, or any other creditor, what can they legally get to? What can they legally get to? So there are loopholes in the law that allow you to legally become judgment proof. Now, a perfect example of that, and I don't think he intended it this way, but was O.J. Simpson. O.J. Simpson had this $25 million judgment against him from the Nicole Brown's family, and they were unable to collect that judgment because most of what he owned a home in Florida, which was a multi-million-dollar home, but in the state of Florida, there is an unlimited homestead exemption. A creditor can't take your home. It's one of the exemptions. Another one he had a pension from the NFL and from CBS Sports. And under federal law, those are protected from creditors. And there's many, many other ones, and we're going to talk about some of those tonight, where you can legally do this and protect yourself from creditors. And sometimes if someone's even threatening a lawsuit and then you share with them the way you're set up, it's going to discourage them right from the beginning. That goes right back to number one, appearing broke. It's not that you don't have anything, it's just that they can't get to it. And the most important thing I really got to underline here is timing. Everything I'm going to be talking about tonight is a preventative measure. Don't wait. Do it as soon as possible. If you're just starting out as a landlord or a real estate investor or a business person, you want to build your business like you build a house, on a foundation. And what are foundations built on? They're built on concrete. What if you built a house on plywood? Well, eventually it's going to rot out and collapse the house. So when trouble comes, you want to make sure that your business is built on a concrete foundation legally. In every state, there are protection laws for creditors that prevent a debtor from getting broke in a hurry. So if you're threatened with a lawsuit, or someone sues you and you start transferring assets to your family and friends, it doesn't work. There's a look back period, and we want to beat that look back period by doing it when everything is fine. And then if years later you go overcome that look back period, then you're going to do much better than if you wait till someone threatens you with a lawsuit or you wait to get served with a summons. So step one, appear broke, hide your assets. The more you can make it difficult for people, whether it be potential litigants, attorneys, the government, anybody into looking into what you do, it's going to make it much more difficult for them to want to think about making a claim. Now, many of you are familiar with the golden rule of law. What's the golden rule of law? He who has the gold gets sued. I bet you thought I was going to say makes the rules. No, he who has the gold gets sued. And that's just a fact of life. If you are a big corporation or a rich person with a reputation, then you're just inviting lawsuits. I mean, that's just the way it is. Especially the media and social media makes just like the paint we landlords as monopoly men who sit around and smoke cigars and laugh about how much we charge for rent. Of course, we know that's a joke, and most properties barely break even, and the cost of everything is going up, and tenants trash places, and you don't make that much money from rental properties. You make more from appreciation of the property, but tenants don't see that. right? They see you as greedy landlord and you're making all this money. Or if you're an employer and you have employees, you're the greedy boss and you're abusing the employees, and you're a rich person and therefore you owe them something. And that's the mental attitude of a lot of people, especially the younger people that really feel that way. So we want to make it so it's very difficult for them to see what it is that you have. And typical advertisement you see on a billboard or on a TV or on a bus looks something like this. Has someone injured you? Car accident, train wreck, dog bite, mosquito bite, call 1-800 let's sue. And someone, let's say, who's a tenant in one of your apartment buildings or homes goes down to the law offices of Dewey, Cheatham, and Howe. And that's a joke. But seriously, in all seriousness, this is how it works. They go down there and they say, hey, I think this person, my landlord, my boss, whatever, has grieved me and I want to sue them. Now, these firms usually work on what we call a contingency fee basis. I know, like, the colloquial phrase is ambulance chaser. I get it. They chase ambulances, but not they don't literally chase ambulances. They have other people chasing ambulances for them. I have a good friend of mine I went to law school with, who is one of those type of attorneys. And if anyone in New York City falls down, a guy comes out from behind a rock and hands them their business card. And I'm only half kidding. So this type of attorney, since they're not charging a retainer up front, they're not getting paid until they sue and win and collect, that's the most important part. Then they want to be darn certain before they take the case on that basis, forking out all the costs and the fees and the time and paying their attorneys and paralegals to file suit. They want to make sure they're going to get paid. And typically these attorneys get a percentage. It's usually 30 to 40% of whatever they collect, plus on top of that all the expenses that they laid out, which can be quite a bit in litigation. And it ends up being 50% or more. So if an attorney is going to take a case like this, the first deep pocket they're always looking for is an insurance policy. That's the big deep pocket. But if it's a claim that may not be covered by insurance, or it's within an exclusion, or they've already tried and there's no insurance coverage, then they have to determine, what kind of assets did this potential defendant have? So let's say they look up public record because this is a tenant in one of your buildings or one of your houses, and they look it up and they say, wow, look at all this real estate. We can go after that, and you're totally exposed. They can look up what the property's worth, what the liens are on the property, and if they see equity or free and clear, even worse for you, then they're going to probably want to take a case because they know if they win, they know where to collect. The real estate just can't get up and walk away like money can. Real estate is a fixed asset. You can't make it disappear offshore. All a lawyer has to do is take a judgment, record it in the real estate records, and now it becomes a lien against your properties. So if you want to sell it or you want to refinance it, you've got to pay them off like a mortgage lien. And if they want to, they can force a sale of your property in an auction through a sheriff's auction. And, these properties don't sell for full price in those auctions. They sell for a lot less. So you're going to get hurt even worse in that scenario because they're lucky if they get 70 cents, 75 cents on the dollar, which is, that means basically they're liquidating your properties. What I suggest what people do is using a device that's a very simple but effective device called a land trust to title properties. Now, we're going to talk a little bit about LLCs and corporations and things like that, but the way you title your property, most people title their property in their own name. So Joe and Jane, landlord, are the owners of the property, or just Joe, landlord. Now, some people put a property in an LLC, which is good because that gives you, number two, liability shield. However, it does not give you privacy, and it does not make you appear broke, because if someone looks up the ownership of a property, it's very easy. online, very simple for free. They're going to look up the corporate entity with the Secretary of State, which is also free and online, and they're going to see your name all over that, and they're going to know, oh, this is who owns the property. This is how I know who to sue. This is why I like trusts. Trusts are private contracts between parties. A trust is not a corporate entity at all. You don't file anything with a database at the state or the IRS or the federal government or the local government. It doesn't get a tax ID number in most cases, especially this type of trust. It doesn't even need to have a bank account. It's a paper fiction. It's an arrangement where someone else, we call a trustee, someone with a different last name than you, preferably, is going to be in charge under a trust agreement to manage that trust property for you, the beneficiary. Okay? Now, this trustee should be obviously someone you trust, someone who's responsible, but they really don't have any responsibility other than what you tell them to do, because the trust agreement says you can't do anything except what I tell you to do, which is different than a regular trust. A regular trust, the trustee has discretion. A land trust, the trustee has no discretion. They act solely at the direction of you, the beneficiary. So you're calling the shots. You're kind of like the guy behind the green curtain in The Wizard of Oz. You remember? Nobody knows who you are. Pay no attention to the man behind the green curtain. That becomes you. And as far as the public sees, they don't know who the true owner is because trusts are not publicly recorded anywhere. Nobody knows who the real owner, the beneficiary is, but you and the trustee. And if it's someone with a different last name, and they don't even have to live in your state where the property is, they can live in a different state. They could live halfway across the world if you want. It doesn't matter. And another great thing is if someone wants to sue the trust, they got to serve process. It's called a summons. It's the first document in a lawsuit. You have to physically hand it to somebody. Now, a corporate entity like an LLC has what's called a registered or resident agent in the state which the company does business and or was formed. They have a physical address. It's required in every state, and that's where you go to serve that summons. It's very easy to get process on a company, but a trustee doesn't have to have that. The trustee could be a P.O. box in another state or halfway across the world. It's very difficult to get that summons on that person. So starting the lawsuit is very complex for that person. Thank you. So a land trust it's an agreement, it's a contract, it's paper. You're going to choose a trustee who's a friend, relative, or someone, an in-law maybe, with a different last name. You sign an agreement, and then you transfer your property into the trust. And you do that with a deed. Usually it's a quitclaim deed. And down at the county now, the record owner becomes the trust. And it's very effective because, again, there's no place to look up who's behind the trust. The only public information is the trustee, which will be at a P.O. box or a UPS store address. They even have what are called virtual P.O. boxes where they scan your mail and email it to you. It's not even a P.O. box. You don't even have to check it. And they're like $8 a month compared to the UPS store. Just Google it, virtual P.O. box. There's a million companies doing it now. So you use that address on record, and anyone who wants to look up, who's the true owner, they can't do it. There's the only person who knows is you and the trustee. And if the trustee is at a virtual P.O. box in a different state, how are they going to find this person? They could mail them a letter and say, I demand you tell me, but that doesn't mean anything. Even a lawyer writing a letter doesn't mean anything. The only person who can demand they give it up is a judge. And the only way to get a judge involved is to file a lawsuit. But the lawyer doesn't want to file the lawsuit until he knows he's going to get paid. You understand the game here? If the lawyer looks up the property that the tenant is living in and they see an anonymous trust and they run that trust name through the database and there's nothing else because every property is in a separate named trust. So we just do something very simple like the property address is 224 Elm Street, 224 Elm Street Trust, 313 Oak Street Trust. So there's no cross-referencing. Whereas an LLC that owns 4 properties, you can search that name through the records and then find everything else it owns. You can't do that with a land trust because everyone's a different title trust. And it's very inexpensive. It's a one-time fee to set it up, to draft it and set it up. And that's it. There's no annual fee. There's no tax returns. The only thing the trustee is going to do, and you're probably wondering, well, if I pick someone like a friend or relative, are they going to be leery about, having to do all this responsibility? No. The only task that trustee will do in practice will be to sign a closing package when you sell the property. That's it. That's all they do. They have no liability because they're not managing the property. And they only can do what you direct them to do under the trust agreement. So now it's kind of like catch me if you can. And this is all part of number 1, appear broke. If they can't find a clear-cut way to get paid, the lawyer at Dooley, Cheatham and Howe is going to tell this potential client, take a hike or pay me $20,000 retainer and $450 an hour, and maybe we'll win. No guarantees. You understand the game? We're trying to get, in football terms, the quarterback. We're trying to sack the quarterback. If they don't have a quarterback, you take the ball and go home and win. All right? And this is a game. It's just a game, but let's play the game to win. All right, step 2, create a liability shield. So a liability shield would be a corporate entity, and that would be something like a corporation or an LLC, limited liability company. First of all, I think it gives you more professionalism using a corporate entity in business or as a landlord. Number 2, there are definitely some tax benefits to using corporate entities. And in some cases, a reduced risk of audit. Do you know that the most audited tax return is a small business person making between $100,000 and $200,000 a year who's not incorporated? Why? Because the IRS assumes you're unsophisticated, you have bad records, you don't keep good books, you're not incorporated, and you probably don't have a good CPA. And you know what? In most cases, they're right. So they audit those businesses all the time. You know that whole thing with Joe Biden and all those IRS agents they were going to hire, to go after the big bad rich people, the billionaires. They're not going after those people. They have teams of lawyers and accountants to defend themselves. It's the person making in the middle, the small business person who's unincorporated, who's going to get nailed. And don't be that person. Okay. Number 3, and most importantly for our discussion, is liability protection. If you form a corporation, you're the owner of that corporation, or you form an LLC and you're the owner of that LLC, you are protected from the liabilities that company engages in or incurs. So if you own real estate and it's owned directly by you, you're going to get sued. If you own a business and your employees work for you, you're going to get sued. If you have a business that's retail and you have customers, you're the owner, you're getting sued. In all 3 of those cases, if you have a corporate entity, it's the corporate entity taking the hit for you. That's the whole idea. Setting up corporate entities, the whole idea is to limit your liability. Okay? So if you use an LLC, for example, and you do it right, and you keep good books and records, and your accounting is good, then there's a very good chance that if you get sued, they're not going to get you. They're going to get the company. Okay, which means your personal home, your car, your bank accounts, your brokerage accounts, they're all protected through this. Now, what's not protected is whatever that company owns, which we'll get to in just a little bit. Okay, so the default rule, and here's the major exception to the rule, which I just alluded to, is the company's assets are not safe. Anything that the company owns, it can lose. So if you run a storefront and the customer sues you, they're suing the company. And if the company owns all the assets, you're going to lose it. If you are a landlord and your company owns all the property, you're going to lose it. That's just a fact. That's why we're going to move on to step number 3, which is segregating assets. Segregating assets into different baskets. Now, there's so many scenarios I can paint for you in this, but I want to do is most of you are real estate people. I'm going to look at it from a landlord's perspective. So what a lot of people do, I mean, owning it in your own name is a disaster. I mean, if you're doing that, I'm imploring you to stop. I know, especially people who are set in their ways, they don't want inconvenience, they don't want to change the way they're doing things, they like the simplicity. Fine, but you're just begging to get a lawsuit against you. It's just not a matter of if, it's just a matter of when. In fact, I took a continuing education class recently where the instructor said he thought it was malpractice for an attorney to do a closing for a client, draft a deed into his name as an investment property, and not urge him to do it in a corporate entity. Malpractice to let a client take title into his own name on a rental property. And I agree with that. I think it's malpractice because as an attorney, you have to say the reality is I've seen it too many times. People get sued. You want that protection. Now, some people do this. I'm sure many of you have an LLC and you put all your properties into one LLC. Now, that will protect you personally and your personal assets, but it's under protection because if they get a judgment relating to one property against the LLC, then they can get all the assets of the LLC. So you can lose all your real estate in one lawsuit. It's better than doing it in your own name. I'll agree with that, but it's not really ideal. Now, what some people do is they segregate it to the extreme and put every single property in a separate LLC. Well, if we're talking about a commercial property, yes, that would deserve its own LLC. An apartment building, yes, that would deserve its own LLC. But a bunch of single family homes and condos that don't have a ton of equity in them, maybe 20, 30, 40% equity, I think it's overkill. It's overkill from a many ways standpoint. Number one, it's expensive. Number two, the bookkeeping is a nightmare because if you're going to make this work, every LLC needs a separate bank account. And every LLC collects rents from the one property, pays the expenses of the one property, and then distributes the profit to you every month or every quarter or whenever you do it. If you do this separate LLC thing for every property and you start robbing Peter to pay Paul, it's going to collapse if you go to court or you get audited by the IRS because they're going to say it's not real. I mean, just imagine you walk into court, someone was seriously injured on your property. A guy walks in there and, he was a fire and he's all burned and wrapped in tape, he's in a wheelchair. And his lawyer is going to say, Judge, he's got 16 LLCs and 16 properties, but it's all him or all them. It's a fiction. It's a sham, Judge. We want all of the properties. Don't let him get away with it, Judge. And you're going to argue, or your lawyer's going to argue, no. They fell on property number 4, which is owned by LLC number 4, and therefore they only get the equity in property number 4. Now, you're not leaving the judge with a lot of leeway here. I mean, it's the judge says he gets the $200,000 in equity in this one property, or he gets the $3 million in equity in all your properties. And he takes one look at the plaintiff in the wheelchair and says, I got to do what's fair. You don't want to put yourself in that situation. So I think if you get a little too cute with this, I think you're shooting yourself in the foot. Especially since if you can't maintain the separateness of these, separate books, separate accounting, separate tax returns, separate money flow, separate paperwork, if you can't do that, it's going to collapse. It's not going to work. So I think a reasonable compromise might look something like this. This is not a one size fits all, but just by example. What we've got here is 1, 2, 3, 4, 5, 6, 7, 8 properties divided amongst 3 LLCs. So if someone falls on property number 1 on the left there, they'll get a judgment against that LLC and you will lose 3 properties out of your 8. Now, I know you're saying, well, I don't want to lose 3 properties. Well, it's better than losing all of them. That's my advice. Don't get too cute. Let's throw them a bone. Okay. So if you're the judge and you say, well, there's 3 properties there, that's not just one. And you could show clean records of 3 separate LLCs with 3 separate bank accounts, 3 separate sets of books, 3 separate sets of records, 3 separate tax returns, 3 separate everything. It's going to hold up. It's going to hold up. Whereas if you get really cute and you have 27 properties and 27 LLCs, unless, like I said, each one is a fourplex or an apartment building or a commercial building, that's different. But if they're single family homes and condos, I wouldn't recommend that. Okay, so the LLCs, it says beneficiary. Beneficiary of what? Well, the layering and segregating is what we're going to do now, because you may be getting confused when I said own it in a land trust, but now I'm saying own it in an LLC. Let me be very, very clear. The title to the property is in the land trust. The beneficiary of the land trust is not you individually, but one or more LLCs. Okay. So in this case, in this scenario, let me see if I can get my little drawing tool here. There we go. So we have this little basket right here is one basket. Now, a land trust gives you anonymity. There's 3 separate land trusts, and it'll make it very difficult for Dewey, Cheatham, and Howe to figure out who the real owner is and, what to do with this mess. Okay, and it may be enough to discourage him from taking the case on a contingency, which means unless this is a wealthy person, or maybe their husband or wife is an attorney, then that's a different story. But most people, not the case. That one basket is 3 land trusts for anonymity that drop down into one LLC. So for liability purposes, the beneficial owner is the LLC. The titled owner at the county is the trust. But the trust is ignored for all intents and purposes for tax reporting, for liability. The LLC is really the true owner for that purpose, but the titled owner is the trust. I know some people have a little hard time understanding the difference between title and ownership. Ownership implies beneficial ownership, taxable ownership, equitable ownership. Title refers to what is on the deed at the county. So there's a trust agreement between this one LLC and the trustee of these 3 land trusts. And there's a separate trust agreement for the other ones as well. Okay. The LLC is the taxable owner. It claims the income and expenses of the properties in each case. Okay. Step 4, we want to become legally judgment proof. Now, as in an earlier example, I talked about how it's possible to become legally judgment proof because there are many exemptions in the law. And one of them I alluded to was a personal residence. In some states, namely Texas, Florida, and a few others, there's an unlimited homestead exemption. That means no matter how big of a house or expensive of a house you own, a creditor can't take it from you. There's one exception, though. If you have a mortgage against the house and you don't pay it, you waive it as to them. They'll take your home. But an outside creditor that has a judgment against you can't take your home. Now, most states have some exemption. So, for example, in your state, if the exemption is, let's say, $250,000, that means if you have less than $250,000 in equity, you've got nothing to worry about on your home. even effectively more than that. Let's say you own a home worth 750 and you owe 300 and the exemption is 250, right? Now, if it's worth 750 and you owe 300, you have 400 in equity and the exemption's only 250. However, if someone wanted to force the sale of that $750,000 home, it's not going to sell for 750 at an auction. Plus they have to pay an attorney to go through the process, which is going to get expensive. So that 750 home may only sell for 600 or less or 550, and then you got the 250 exemption, the $300,000 mortgage, there's nothing there. There's no meat left on the bone. So don't worry about if you have a little more, 20, 30, 40% more than the exemption in equity, you're still pretty much okay. Now, if you have a home free and clear, on the other hand, and your exemption is only 250 and your home's worth $1 million, some of the things you can consider are as follows. Number one, you can get yourself a home equity line of credit for 80% of the value of the house. Now, someone looking on public record doesn't know how much you've drawn on that line. You could have drawn all 800,000 or zero, but they can't tell that from public record. So that may be enough to dissuade someone to saying, well, yeah, they do have $1 million home, but they've got an $800,000 potential of debt against it. And that may be enough to scare away Dewey, Cheatham, and Howe. Okay. Another thing that I do sometimes for clients is we put friendly mortgages against properties. So if you own them free and clear, we create a mortgage company. And with an anonymous filing and an anonymous state, we create a company that looks like a mortgage company and place mortgages against your properties. Now, will that hold up in court? Of course not. It's fake. It's a sham. But what's rule number one? Appear broke. It's not illegal to do it. It won't hold up in court. But if someone looking from the outside says, oh my goodness, look at all these liens against these properties, I don't know if it's worth going after. That's what you want. All right. Becoming legally judgment proof. So if someone gets a judgment, what can they get from you? One of the greatest and oldest tools in the toolbox is what's called a family limited partnership. Now, this is a limited partnership generally between family members, but if you're a single person, there's still a way to do it. I don't want to go too far in the weeds with that, but you could still use one of these. You've got typically husband and wife who are general partners owning 1% each. Now, in a limited partnership, you have general partners and limited partners. The general partners run the operations, and the limited partners are just passive investors. You can also be limited partners. So you can be both a general and a limited partner, but it has to be two people. I said it earlier. If you're one person, you could still do this. There's just another way to skin the cat, so to speak. But don't get caught up in that. Just pay attention. Husband and wife are 1% each general partner and 49% each as limited partners, which totals 100%. The way this is set up, assets in a family limited partnership are nearly judgment proof. And this has been around for 100 years. There's 100 years of case law that says a creditor cannot get to your interest in a family limited partnership. So if the family limited partnership owns assets, they can't liquidate it to get your share. And it makes it very, very difficult for them to get to anything if everything is piled in this. Now, you're probably wondering, wait a minute. You said land trust, then you said LLC, now you're saying limited partnership. Which one is it? We're going to do this in layers. This is my full bulletproof system. And by the way, this is not a one-size-fits-all. Any attorney who tries to sell you on a one-size-fits-all, grab your wallet with both hands and run. Everybody's going to have a different scenario. I'm going to advise you to speak with an attorney who's qualified and knows what they're doing here before you just everybody do the same thing. Okay, so just let me say that first. So going back to the property, the 8 properties, we're going to put each one in a separate land trust. That way you have anonymity. Each one has a different named trust. There's no way to cross-reference them. There's no way to look up the beneficial owner. The beneficiaries, as we talked about earlier, we broke it up into 3 LLCs in this case. Now, An LLC is owned by what we call its members. In a corporation, they're called shareholders. In an LLC, they're called members. And in a limited partnership, it's called partners. Just get the vernacular down. If the LLCs, if we just did this would be pretty darn good. The only problem with this is LLC 1, LLC 2, LLC 3, you got 3 tax returns there if you have 2 members of each one. Now, what you could do is just have husband and wife, or if you're single, be single owners. The problem is single owner LLCs, especially in Colorado, have virtually no judgment protection. Virtually none. LLCs in some states have the similar protection to family limited partnerships, but it's vastly different from state to state, and the law is still in flux here. So what I like to do is put all 3 of these LLCs, their ownership, the membership, into what we call a parent or holding company. Many of you have heard that expression before, a holding company or a parent company. Think General Motors. That's a parent company. It has subsidiary companies that it owns 100% of. Buick, Chevy, GMC, etc., Cadillac. We're going to do the same thing. So we'll form a parent or holding company, which would be the family limited partnership. And I recommend Delaware or Wyoming. Those are the 2 best states, in my opinion, for a family limited partnership. Now, the yellow LLCs should be in the state or states in which you own properties. So if you own properties in Texas, Florida, and Colorado, you would have 3 separate LLCs in 3 different states, but they'd all be commonly owned by the parent or holding company, the Wyoming or Delaware Family Limited Partnership. What's nice about this setup is all of the tax reporting goes on the parent company. The subsidiaries don't file tax returns. They're ignored for federal income tax filing and state income tax filing. So for liability, they're separate entities. Each one is a separate basket. For the money flow, each one has to have a separate bank account. That's the bad news. I'm sorry. But if you bank with electronic banking, it's not that difficult. And you have a bookkeeper handle all the bookkeeping. If you're one of those people who's, let's say, a little older and been doing it and you're set in your ways for a long time and you're owning everything in your own name, I know you're going to have resistance to this because you're going to have to change the way you do things. And I'm sorry if you're used to it, but it's just not worth the risk. You're going to have to change and overcome this little bit of learning curve. Now, you can hire a bookkeeper. That'd probably be the best thing to do. And I'd probably recommend you have a property manager too, because if you have a property manager and all your properties are owned in trusts, the tenants don't know where to go. You probably know this, those of you who have a property manager, that if you own properties in your own name, or even in an LLC that they can look up, the tenants, when they don't like what the property manager has to say, they figure out who the owner is and they bug them. I had many years ago when I did it that way, I had a tenant go on my Facebook page and start bad-mouthing me. And I was like, whoa, who is this person? I don't even know who they are. They're a tenant one of my properties, apparently. That my property manager, told them no, and then they went, and complained online. So the land trust will take care of that. The LLCs will give you liability protection, and the holding or parent company, the family limited partnership, makes it darn near impossible to get through the back door. Now, let me explain the difference between outside and inside liability. Outside liability would mean someone gets injured on one of the properties and they want to sue the owner, which is the LLC. It's the trust, but the trust gets peeled back and the LLC takes the hit. That's outside liability. Inside liability would be someone who gets a judgment against you totally unrelated to this, and then tries to get through the back door into your properties through your parent company. They can't. it's extremely, extremely unlikely that they can do that. I never like to say impossible as an attorney because judges sometimes do crazy things, as we've seen lately, and with the politics, and rogue judges, things do happen. Um, you may win on appeal, but you don't want to get that far. You want to make sure that you're set up in a way that discourages litigation in the first place. Okay. So this is the way it looks as a kind of multi-tiered, multi-basketed, and not everybody's going to do this. You might have part of this. You might start with just the land trust and the LLC. If you have a few properties, that's where I'd recommend you start. If you have many properties, I'd recommend something like this. Okay. All right. And remember, again, I can't urge you enough to not wait until something goes wrong. Don't wait until something goes wrong. Do it while everything is calm, the waters are calm, no one's threatening you, no one's suing you, because again, there's a look back period, and depending what state you're in. And it's usually about 3 to 4 years. So you want to get that clock running and get this done as early as you can. Early as you can. Okay. I'm going to make a special one-time offer that Mike has twisted my arm to offer you folks as a special pricing for some of the stuff that I talked about if you want to hire my firm to do it. First thing is a consultation. So I don't generally do free consultations. I'm not a personal injury lawyer, so I don't do those types of things. So I do charge for my time. It's $4.75 an hour. But if you want to do a half-hour consultation, which is probably more than enough to discuss this, it's $100. And I'm putting a deadline on it too. The deadline is Thanksgiving. All right. You don't have to do it by Thanksgiving, but you got to contact us and set it up by Thanksgiving. Because why am I doing that? Because I want you to not wait. Again, timing is everything. So I want to put a deadline on this. Number two, if you've just got one property, like one LLC, one single family home or one fourplex or something like that, one property, land trust plus an LLC, $1,000. And it's normally $1,500. Either way, it's plus the state filing fee, depending on where your property is located. So if it's in Colorado, it's very cheap. It's only $50 for the filing fee. And we can act as your registered agent at no extra charge. Most companies and law firms charge annually $100 to $150 fee for that. We don't do that. So if you've got one property or you've got two properties and you want to do two properties like this, it's $1,000 for each one. And if you want to get more serious about it and you already have an LLC or two and you want to do the parent holding company, the family limited partnership, that's $1,500, normally $2,500 plus the state filing fee. And if we do it in Delaware, it's about $280. If it's in Wyoming, it's about $150. So that's what you're looking at. All right. So this is how to contact me. My website is bronchicklaw.com. Email bill@bronchicklaw.com, or if you prefer phone, you can call 303-398-7032. My office is located in the Denver Tech Center area in Greenwood Village. But of course, we can do Zoom, phone, email, whatever, especially if you're located out of state. So if you want to take advantage of one of these or more of these offers, just reach out one of these three ways before Thanksgiving, and we can do that for you. Most people start out with a consultation and then we'll customize something for you. But if you know exactly what you want, you got one or two properties and you just want to do it, then just drop me an email or give us a call or fill out a form on the website, and we can get you taken care of. Okay. All right. Let's take some Q&A.
Awesome. Thank you, Bill. Appreciate
Thank you.
Bill. Great. We've already got a couple questions. I'm going to give everybody a chance. If you have a question, go ahead and put it in the Q&A section of this. But first, we've got a question from Monica. Monica wants to know, what if you already own the property and there's a mortgage? Does the mortgage company have to approve transferring the deed to the land trust, especially if there's a due on sale clause?
Nope. There's a specific exemption under federal law for transferring a property into a land trust. And as far as LLCs, first of all, in 35 years of practicing law, I've probably transferred 1,500 deeds from clients' names to LLCs or trusts, and not a single bank ever balked. so that's the pragmatic thing. But actually, Fannie Mae explicitly came out with a rule that starts January 1st that says you could put it in an LLC and we don't care.
Excellent. Thank you, Bill. All right, another question from Frank. I have a substantial blanket policy that covers my properties. Why isn't that adequate personal protection?
That's a great question. Thank you. Insurance only covers what insurance covers. A lot of people think that an umbrella policy covers more than regular insurance because you think umbrella like wide. It's not. That's a false sense of security. And this is the way an umbrella works. Let's say you have a $500,000 policy for liability on your rental, and you've got $300,000 on your car. You could buy up to $2 million worth of umbrella very cheaply. So if you got into a car accident and someone was injured more than 300, the first policy would pay the 300. The umbrella would pay anything more than that, up to 2 million. Same thing with the rental property. So it's not horizontal coverage, it's vertical coverage, more money, not more things. If your primary policy doesn't cover it, neither does the umbrella. And my first job out of law school was working for an insurance company law firm. They're really good at two things: collecting premiums and denying claims. There's a million reasons why they can deny a claim. So I don't trust them as far as I could throw them. I wouldn't say cancel your insurance. No. Don't get me wrong. Insurance is necessary because if you get sued, even if it's bunk, and you have to pay a lawyer 50 grand to get it dismissed, you lose. But if you have a free lawyer from the insurance company, you win, right? So it's definitely a good idea to have plenty of insurance. I highly encourage it. But when insurance doesn't cover the claim, or there's an exclusion, or you didn't report it timely, or 100 other reasons they can not pay it, this is your backup insurance. Does that make sense?
Excellent. Yep. Thank you, Bill. Miranda asked, can a property be refinanced once put in an LLC?
It depends on the type of loan you're getting. Usually Fannie Mae, Freddie Mac, they don't like any type of entity. So if it's in your name when you got it and then you transferred it to an LLC or a trust or whatever, and you want to refi it with the same type of loan, they're probably going to make you deed it back to your name, refi it, and deed it back to where you had it, which is not ideal. But there are plenty of other types of lenders who will do that. Like here in Colorado, First Bank, I've financed properties in a land trust with an LLC underneath and another parent company. They didn't care. As long as they can get a valid legal lien against the property and a personal guarantee, they're fine with it.
Good. In a follow-up to Monica's question earlier, Bill, if you have the property in your name and then you want to move it into your LLC, talk to them briefly about how that works before you do that into a land trust.
Well, usually we're going to go directly into the land trust with a trust agreement that says the beneficiary of that trust is the LLC. So it's not a two-step process, it's a one-step process. Well, actually, it's a two-step. Let me back up. You create the trust agreement and then you deed it into the trust. But it's not two deed transfers, is what I meant to say.
Excellent. Thank you, Bill. Scott just asked, if you layer a mortgage property under a land trust and an LLC, is it possible to pull equity out of that house through a refi? I think that's similar to Frank.
Yeah, same thing. Yeah, as long as most non-Fannie Freddie lenders will do it. DSCR lenders have no problem with it. Like a commercial bank, a local commercial branch bank, a Wells Fargo, they're okay with that type of thing.
Okay, we got another question in the room.
Hey, Bill.
Hey.
So I've got a question. So if I've got a bunch of properties in my personal name, and then I go to change it into an LLC, won't it be obvious that they were mine because I just quick claim them across? How do I deal with that? Because a lot of people are in that situation.
Right. Well, that's another reason why I use the trust, because the trust throws people off. If it's the same LLC and you put multiple properties in it, it doesn't take a genius to figure out what you're doing, especially since the public record of the LLC is easily traceable to you if you don't do it right. Most people, when they look up the ownership, they're going to look under the tax assessor records, which just shows current owner, doesn't show the history. To do that, you have to do a title search. And the average knucklehead doesn't know how to do that, and they don't want to pay for it because it costs like $50 a search per property, and they have to know which properties to search in the first place. Because if they're searching your name under current ownership through the counties, they're not going to come up with anything. Does that make sense?
Yeah. So then just with that, then how quickly, if I was, if I've listened to your presentation and I'm freaking out now, how quickly do I?
We can do this. I mean, as long as we get all the data that we need promptly, we can do it within a week or two.
Because that's that look back period you were talking about earlier, right?
Oh, the look back period, yeah, we can get this done within just a couple of weeks. I mean, depends on how complex you are and how long it takes you to get all the data to us. But usually we can do it in a week or two, unless it's extremely complex. And then the other topic, which I didn't even cover, we'll do some other time, is the succession planning. I mean, how are you going to take this empire you've created and leave it to your family and to your kids and grandkids in an orderly fashion, in a way they can't liquidate it too quickly and have a party?
Thank you.
Yeah.
Good. Any other questions out there before we let Bill go and give you guys some final thoughts? Oh, Ann just asked a question here. And for estate planning, how would I actually leave these for my 3 kids?
Excellent. And it's very simple. At the bottom of the equation is your parent company. That dumps into your living trust. And what you're leaving to your kids are not a bunch of houses. It's the keys to the parent company and everything that flows through it. Makes it so much easier for estate planning.
Excellent. Thank you. We've got another question here. If grouping single houses into an LLC and want to sell one of them, how does that work?
Not a problem. If it's in a trust and the trust is owned by the LLC, you're going to direct the trustee of that property trust to sign a closing package. So the trust lists the property with the broker. The trust is going to sell it from its name as trust to the buyer, which means the trustee is going to have to sign the closing package, which they can do remotely. Nobody does live closings anymore. Everything's done remotely.
Excellent. Thank you, Bill. Last opportunity to ask questions, but while you're typing those questions, I want to encourage you guys with a couple different things. First of all, if you enjoyed Bill this evening, just give him a thumbs up or a high five in there. I appreciate
Thank you.
it. Did a great job. I would encourage you with a couple different things. First of all, I would encourage you to take advantage of that offer. You can't even get a licensed plumber to come out for $100.
Yeah.
That is a very worthwhile offer. Thank you, Bill, for being generous and doing
Sure.
that.
Sure.
Second of all, if you guys enjoyed this and you'd like to be invited to additional things, whether it's investment opportunities, wanting to know about additional upcoming training, seminars, discounted experts like Bill, they're not discounted, opportunities to get in front of experts like Bill because of the large audience we have. Just make sure you reply back with your email to us, give us your info and say, hey, please count me in on that. Looks like we got a couple more questions here. One more here. Are there benefits to a corporation over an LLC?
I give you the lawyer answer. It depends. There are proper uses of a corporation in this equation that I didn't have time to really get into. And it really depends on what type of activity you're doing, whether you'd use a corporation over an LLC. There are uses of a corporation, like an S corporation or C corporation, over an LLC. But generally speaking, with passive activity like rentals, you want to use an LLC. You don't want to hold rental properties in an S corp. That's generally a bad idea.
Excellent. Well, one more question, last question, and then we'll wrap up here. There's lots of thank yous and great jobs, but does the 1031 apply to a trust and LLC to apply to trust and LLC and trust when selling an investment property?
That's a great question. So the taxable owner of all of this is your parent company. So in a 1031 exchange, you don't have to replace the property in the same titled name. It's the same taxpayer. That means the trust is ignored. The LLC, meaning when you sell the relinquished property, you're going to do that from the trust. The replacement property can be either in another trust, the LLC, or the parent company. They're all the same taxpayer. Done it many, many times.
Excellent.
The short answer is it doesn't frustrate your attempt to do a 1031 exchange. It's just, it actually gives you more options.
Absolutely. Well, thank you, Bill. I want to respect your time. Thanks for taking the time this evening. Again, every one of you, thanks for being a part of it.
Thank you, everybody.
Even on a daylight savings adjustment, we had a couple people let us know that their calendars were off. But thank you, Bill. We look forward to working with you guys in the future, and do take advantage of Bill's offer there. You guys, God bless. Wonderful night.
God bless.